joining us today for Make America Safe Again, an update on U.S. regulations. My name is Tonya Esposito, and I am a partner with the law firm Seyfarth Shaw, resident in Washington, D.C. And joining me today is my colleague, Renee Appel, who I will introduce to you momentarily. But before we get started, just wanted to provide a little disclaimer to let you know that the information we're providing today is not to be intended as legal advice, but just general information. And if you do have legal issues or need further legal counsel, we're happy to assist you in that regard, or you should contact an attorney to get actual legal advice. As I mentioned, I'm joined today by my colleague, Renee Appel. Renee and I are both resident in the Washington, D.C. office, and our practice involves counseling and litigating on behalf of clients in the personal care products and consumer space, including cosmetics, and practicing before both the Federal Trade Commission and the Food and Drug Administration, as well as the state's attorneys general. We handle a whole variety of types of matters, and we really enjoy what we do, and we're super happy to be here today with you. Here's the agenda for our program today. We're going to start off by speaking with you about recent FDA enforcement activity, and despite the pandemic, there has been quite a bit to talk about, so we're going to review that together, as well as FTC enforcement activity. And relatedly, we'll talk through some lessons from private litigation or class actions. We're also going to talk to you about federal cosmetic reform and what's happening in that space, as well as at the state level. And we'll end today with some questions. So, as mentioned, starting today with FDA enforcement activity. Despite the pandemic and sort of the lockdown of society generally and the slowdown of the economy, there have been a fair number of warning letters gone out to companies by the FDA, and we thought it would be useful to walk through some of those with you. So, in the adulterated cosmetic space, or warning letters related to that particular issue, we've seen one in particular that has been sent to a company that does custom products and packaging in health and beauty product space. And that warning letter went out in September of 2020 and was directly zeroed in on or focused on unsanitary manufacturing, and focused really on this particular manufacturer's failure to clean their facility, failure to have written procedures, using the wrong equipment, failure to have a testing program. And so the FDA made it very clear that these are the types of conditions that do not comport with current good manufacturing practice, or CGMP, and highlighted, all of these various points that they found were in violation, gave this particular manufacturer 15 days to address all of these violations and to respond to all of these violations in writing. And so, the takeaway there is to make sure that any type of manufacturing activity that's happening at a facility does comport with CGMP and is abiding by what the FDA is expecting in terms of cleanliness and orderliness and written procedures and the like. And they're very extensive, and I won't go into them there, but it's just very important that companies are aware of those obligations. Let's see, there's similar warning letter that went to a company that produces enzymes, including soap enzymes, and that went out in February of 2020. And that particular company was making claims that these particular enzymes could help with cancer and AIDS and the like, and that's clearly problematic. But in addition to those claims, they were also lacking in cleaning measures, were allowing pets in their facility, using dirty containers and equipment that wasn't sanitized. And so this entity also received a warning letter, basically highlighting all of those violations and noting that, from the FDA's perspective, these cosmetics were adulterated and being manufactured in unsanitary conditions in an unsanitary manufacturing environment, and similarly received 15 days to correct those violations and explain very explicitly what it was they were doing to address the situation. So those are just two examples of what we saw of late addressing those types of issues. We also saw a warning letter in connection with entities that are actually in receipt of adulterated cosmetics for distribution. And so in this particular case, this company was in receipt of products that were coming from manufacturing facilities that were known to have not been in compliance with FDA expectations. And so, lots of violations within the supply chain. This particular company was continuing to do business with these distributors, despite the fact that it was clear and public that a lot of these companies were and have been and continue to be in violation. And so this particular company was told that, similarly, they needed to meet with the FDA and explain and address all of these, and also had 15 days to address all of the violations. So I think the takeaway there is, if you are doing business with a supplier or a manufacturer who's providing products to you, you need to have confidence that that particular manufacturer or supplier is also adhering to all of the FDA's expectations for in connection with packaging and manufacturing and cleanliness in their facility generally. I mean, it's really not an excuse to say, well, I'm just purchasing product from this entity, or I'm just in receipt of these products. I'm not responsible for the manufacturer. The FDA really doesn't, sort of make that distinction. And that warning letter that I just mentioned makes it clear. Another category of warning letters that we saw were for misbranded drugs. And so another cosmetics company that was producing soaps, face masks, and other skin treatments, claiming to have a drug that, or apologies, have a product that could engage in a process of deworming, removing toxins from the gut, or handling connective tissue disorders and pain. And so generally speaking, this warning letter addressed the fact that all of these claims were not connected with products that are generally recognized as safe and effective to treat these types of conditions, or and so the FDA, came to the conclusion that these products were actually not cosmetics from their perspective; they were drugs. And so, the sort of interesting piece of information to note with this warning letter is this company was also producing products that were intended to treat animals. So in addition to being intended for human consumption, they were also intended for animals. And the FDA said that not only were these drugs as they relate to humans, but also drugs as related to animals, and therefore all of these claims were inappropriate and these products were deemed misbranded. And again, the FDA expects a prompt response to this, a meeting, a response in writing, and a pretty swift recognition that these are serious issues. Similarly, as we've seen, throughout the marketplace, the FDA continues to issue warning letters in connection with over-the-counter CBD topicals, and in particular in connection with pain relief claims. We see that, the FDA continues to repeat the fact that they've not approved any over-the-counter drugs or anything over the counter containing CBD for these types of applications, and yet we see the marketplace flooded with these types of products containing CBD making pain relief claims. And so, as we'll talk a little bit more about shortly in connection with the FTC enforcement activity, the FDA remains, cognizant of these companies and these types of claims, and continues to issue warning letters highlighting the fact that, from their perspective, this is inappropriate and needs to cease. And similarly, those companies need to respond in writing and engage with the FDA about these particular products and claims. We thought it would be helpful just to mention briefly that the FDA has had some recent public meetings during the pandemic. So in February of 2020, they did hold a public meeting in connection with testing methods for asbestos and talc in cosmetics products. And during that meeting, they discussed a federal interagency working group, as well as methodology and development of standard testing for purposes of addressing this issue. So that was sort of the one agenda item that we saw on the FDA's calendar over the past year in terms of public-facing meetings. Another bit of information that's worth mentioning is some import alerts. We saw two that were applicable here and important to mention, including color additive violations and microbiological contamination. And both of these alerts essentially highlight that the fact that if these products, if there are products that are coming into the United States that either contain certain color additives that are not on the approved list that the FDA has released and is publicly available and well known, that those products can be confiscated and held upon they're entering into the country without any further inspection or further sort of negotiation about that. It's just sort of part of the FDA's regulatory protocol. And same for products that are known to contain microbiological contamination or come from entities that are on what's known as a red list, basically, of companies where it's well aware that these issues are present and these products, from the FDA's perspective, are contaminated. So I'm going to move to the next slide so that we can talk a little bit about FTC enforcement activity. And so some of the hot topics we've seen the FTC cover over the past year plus include customer reviews. And so, the customer review is really a big part of the customer or the consumer experience nowadays, if you will, with the prevalence of e-commerce and the way in which consumers decide what products to choose and what products to consume. And so, there has been some very, very big litigation here in the United States concerning this issue, and in particular, one instance concerning a company that was actually charged with engaging in fake consumer reviews to boost, the likelihood that customers would buy their products. And so those customer reviews were posted on social media and the internet and the like, and obviously that's a practice that we advise against, and that the regulatory agencies, including the FTC, find to be illegal and will certainly pay attention to. And in this instance, it was the subject of a pretty big and well known litigation here in the United States. But interestingly, the FTC, as the regulatory body who brought this case, actually resolved the matter during the prior administration for a certain set of circumstances and an agreement by the company to cease certain practices, but no monetary penalties. And so that's been a bit of controversy in and of itself, just because the current administration I think, and certain, group of consumer protection enforcement regulators think that that is not appropriate or not as effective as it could or should have been, particularly for an issue of such importance, and one that is going to continue to be prevalent, in the marketplace here in the United States. And it's worth noting that the FTC issued its sort of opinion here, and one of the commissioners was very vocal about the dissent or disagreement with the decision to not impose a monetary penalty. And so what I would say about that is I would expect that as we move forward in the current Biden-Harris administration, we anticipate that we will see a much different approach to these types of investigations and litigations. I would expect that we're going to see a far more aggressive tact when it comes to bringing cases like this, and the penalties that will be assessed in connection with these matters. A couple of these are also, worth mentioning, but pretty obvious and standard for purposes of the types of actions that the FTC brings and has brought for a number of years. For example, made in the USA claims. It seems pretty obvious that this is, something that all folks who are doing business here in the United States should know and likely do know. But if you're selling a product and claiming that it's actually made in the USA, you should make sure that that's actually the case. While this has not been an issue that has been at the forefront of the FTC's enforcement scheme, over the past 5 or 10 years, it's one that they continue to litigate simply because there are companies that continue to sell products here and claim that they are made in the USA, when in fact it's abundantly clear that they're not even any portion of the product. And so that's just something to keep in mind, that the regulators pay very close attention to and will continue to engage in enforcement activity. The mail order rule. There has been some activity around this rule as well, and essentially there's one big case involving a large company that sells fashion and other products, where one of the key things they were sort of proposing to consumers on their website and beyond was that they had fast shipping and express shipping, and products would be readily available and the like. And as it turns out, consumers were led to believe that these products would in fact reach them in a certain amount of time, when that was not the case. And so products were often back ordered or not available at all. Consumers were left to sort of, wait and wonder if their order was ever really going to make it to their doorstep based on their transaction. And this particular company was not sort of forthright in complying with the mail order rule, in that if there is to be a delay in the shipping of a product ordered by a consumer, a company is obligated under the mail order rule to tell the consumer that, to say, hey, this product is not going to ship in the next 7 to 10 days or whatever the agreed time frame is. It's actually going to be delayed by a week or 2 weeks or whatever the date may be. Would you still like to proceed with this order, or would you like to cancel it for a refund? And that's essentially what the mail order rule requires. And this particular entity was not doing that. And what they were doing in most instances was offering a credit or some form of a gift card. And the FTC made clear that, one does not substitute or constitute the other. A full refund is not the same as receiving a store credit or a gift card. So that's just another rule to keep in mind if you are endeavoring to engage in commerce here in the United States. Another hot topic is influencers and endorsers. The FTC continues to be sort of aware and involved in this type of activity by consumer entities, particularly as it relates to the sale of products on websites, on social medias, and the like. The bottom line here is that if you are going to rely on an influencer or an endorser to help sell your product, you have to disclose that to the consumer. You have to make it clear in your advertising or in your marketing that the product that this particular famous person, or maybe not so famous person, is selling is being presented by someone who has an affiliation with the company, someone who is being compensated by the company, or otherwise. The consumer is just entitled to know what the relationship is and how that endorsement came to be. So really important to keep that in mind. The FTC's brought a number of cases in connection with failure to disclose that information to consumers or to the general public. CBD, as mentioned previously, is also a hot topic for the Federal Trade Commission. And so while the FDA looks at CBD from one lens, the FTC kind of looks at it from another, and there is a little bit of an overlap in jurisdiction there. What the FTC is focused on, essentially, as it relates to CBD, are the claims false, misleading, deceptive in any way, right? Are you selling a product and claiming that it contains CBD and it's going to cure your allergies overnight, or make your skin smoother within 24 hours, or it just really depends on what the claim is. But for the most part, the FTC and the FDA have been jointly proceeding to send warning letters or to speak about CBD. And the bottom line is that there is no definitive rule or regulation in place currently as it relates to, on the FDA side, the consumption of CBD and or the use of CBD in any drug product. And relatedly, on the FTC side, it's somewhat impossible to substantiate claims that are made with a particular cosmetic or consumer care product, because there really is not the science or other publicly known testing or literature available to support those claims. So that's something that is going to continue to evolve, as we know, and it is, certainly on the FTC and the FDA's agenda, and will continue to be on their agenda, is what we expect. So it's important that companies that are endeavoring to develop or market products that contain CBD in the United States consult with counsel to best sort of minimize the risk or eliminate the risk of marketing or selling those products. Privacy continues to be a big issue for the Federal Trade Commission. It has been, for a number of years, obviously. But, in today's economy, we see that coming up in a number of different ways, anywhere from e-commerce transactions to the disclosure of information electronically in myriad ways, right? And so there's PII collected, personally identifiable information collected, and transactions that occur online versus text messaging versus over the telephone. And so we see the FTC remaining active in that space to ensure that companies that are selling products to consumers and including cosmetics and personal care products are taking good care to obtain the appropriate consent when collecting information from consumers, and to protect that information to the extent they have consent to collect it when they have it in their possession, to maintain it in a way that comports with what the FTC expects for purposes of privacy. And so that's just another point to keep in mind when engaging in business here in the United States. And in COVID-19 issues, we've seen a number of entities engage in ways that are suggesting that products, and those include cosmetic and personal care products and beyond are somehow helpful for purposes of mitigating or preventing the spread of COVID-19. The FTC has been very active in responding to those types of claims. And again, some of that is in conjunction with the FDA as appropriate. And while that has certainly been at the forefront during the pandemic, we expect those types of investigations and enforcement actions to continue well after the pandemic is over, because there are a number of market players who have endeavored to develop and market products in this space that simply are problematic from the FTC's perspective, just because of the types of claims that are being made that cannot be substantiated from the FDA's and from the FTC's perspective. Finally, in the FTC enforcement world, it's important to note that the FTC have publicly acknowledged that there has been lots of sort of confusion and complaints about the way in which rules are promulgated by the FTC. And so they have recently formed a new rulemaking group, which we expect will help clarify for the general public and for companies who want to do business in the United States how these rules are to be applied in practice in terms of when you're actually functioning as a company doing business here in the United States. So all of the rules that we've reviewed here, or the issues I should say, and many, many others, this rulemaking group is going to focus on providing practical, clear guidance on what companies need to know for purposes of being in compliance. So we expect that to be tremendously helpful. Moving along, next we're going to spend some time talking about lessons from class actions. And so the one thing that I'll mention at the start is that oftentimes we will see the FDA or the FTC bring or open up an investigation, potentially eventually turns into an enforcement action for one or more violations of FDA or FTC rules, and that can subsequently lead to major private litigation here in the United States on behalf of a class of persons similarly situated. And so we thought it would be helpful to highlight just a few of the lessons that it's important to know about in this space in connection with selling cosmetics and personal care products here in the United States. So false claims and ingredient disclosures, that seems to be probably one of the biggest points where we see litigation filed as the result of companies who have been in a situation where they've either been investigated by the FTC for making claims in connection with a particular product, or failure to disclose certain information in connection with a specific ingredient, or misrepresenting what the ingredients are. These are all sort of compliance issues, if you will, that if addressed at the front end, certainly will prevent, or hopefully prevent, an enforcement action or a regulator from being interested in even investigating a company or a particular claim in association with a product. But if you can prevent that, then the likelihood of a class action forming in connection with the same issue is great. And so we just wanted to highlight that this is a big issue, right? And so if you can work on that from the compliance perspective up front, it's so much easier than trying to fix it on the tail end after an investigation or an enforcement action has taken place, whilst in the middle of a class action, or even after a class action. So addressing those types of issues in connection with ingredients and claims made in association with those ingredients is very important and a worthy investment from our perspective. Another big area where we see class actions being brought here in the United States is fee disclosures and auto renewal. Oftentimes, consumers will engage in or sign up for a service or a monthly subscription or some form of repeat purchase where they are signing up for something that they're going to be charged for more than once, right? And they're authorizing you to charge their credit card. However, there may be additional fees associated with those transactions, or there may be less than appropriate disclosures in connection with the renewal of that purchase or subscription. And those are similarly sort of issues that class action counsel or lawyers who work in this space, who bring these cases on behalf of plaintiffs, will focus on because they seem to be prevalent. And again, these are issues that can very easily be addressed at sort of on the front end of when you're establishing a practice to sell a product or to offer a service to consumers, and far more easily addressed initially than subsequently. And so in addition to these being issues that class action counsel will focus on and private litigation will stem or will form from, they're also similarly issues that the agencies and the FTC will also pay attention to. So we have a few more that are interesting, and I'm going to turn it over to Renee because she's going to take care of talking about the next three. Renee?
Tonya. So turning to the next topic here, we have failing to disclose side effects. So as I'm sure you all are familiar, US law requires manufacturers to test their products for safety or otherwise disclose to consumers that the product has not been tested. So specifically, there's a federal law that provides that each ingredient used in a cosmetic product and each finished cosmetic product shall be adequately substantiated for safety prior to marketing, and that any such ingredient or product whose safety is not adequately substantiated prior to marketing is misbranded unless it contains the conspicuous statement on the principal display panel of the product that reads, "Warning, the safety of this product has not been determined." So as you would expect, most manufacturers and distributors do not use that particular warning. So the expectation and understanding of the consumer is that the product has in fact been appropriately tested and adequately substantiated. And it is, unique to the fact that it's not just on the ingredient level, but also the finished product has in fact been tested and it is deemed safe by the manufacturer. So while there are no specific testing requirements that the FDA or the FTC, expect, most manufacturers of cosmetics perform a safety test by performing patch testing to determine if a product causes any adverse effects. And then more generally, with the FTC, when they're looking for adequate substantiation, they're looking for literature, they're looking for individual testing or otherwise clinical trials. And when it comes to the safety, though, largely when it comes to the finished product, the expectation is that the finished product has been tested at a minimum by this patch testing. What we've seen on the litigation and class action front is manufacturers failing to disclose side effects on product packaging, which is something that you would expect would come to life if you performed the responsible safety testing. So in these types of actions, plaintiffs maintain that it's deceptive advertising to fail to disclose the harmful side effects of the product. And the lesson here is really that before product launch, to ensure that you've completed the adequate testing required under federal law in the US, that you have performed the testing and that you've disclosed any harmful side effects. And of course, if companies learn of issues after a product launch, so something that may have not come up in your individual testing, that it's incumbent to follow the FDA's protocol for adverse event reporting, and then to follow up and make disclosures to consumers and retailers appropriately. And that will depend on the situation, whether or not it's appropriate on a website? Is there a notice means by which to get in contact with your consumers? And likewise with your retailers and product distributors. So the other part is, as a practical matter, you want to ensure that you have a policy and a procedure in place for responding to and managing any consumer complaints that arise due to the product's unexpected side effects. So turning to the next topic is product packaging malfunction. This issue is really an extension of the traditional slack fill cases, where consumers bring an action for misrepresentation or deception based on the product packaging because the usable contents are less than the net amount that's advertised on the packaging of the product. So this issue is sometimes referred to as the dispense or distribution rate, such that what the consumer is able to actually access out of the product is less than, again, what is on the product packaging. So the U.S. courts have addressed this issue and generally found that because federal law under the FDA requires manufacturers to label their products with the net quantity of the product, that regardless of the amount that's actually accessible through the product packaging, that these types of claims are preempted by federal law. So in other words, the FDA requires companies to disclose the net quantity that's contained in the products. And plaintiffs' counsel, or these consumers, are essentially seeking to impose additional disclosure language that's not required. So regardless of how much your pump is able to actually get out to the consumer, the important piece is what the FDA requires, and the FDA requires you to disclose what is actually in the product. What is that net amount? So regardless, you should still consider independent testing to ensure your products are, functioning properly, that there really isn't an issue in the product packaging, and that, to make your consumers happy and obviously to prevent this type of litigation is to ensure that the products are working as your consumers expect them to be working. And finally, to talk about oil-free and natural claims, this really falls under the umbrella of what Tonya was talking about earlier as to false claims and ingredient disclosures. We thought it was important to underscore these particular claims because they are most frequent in the space of cosmetics. So on these ingredient specific issues, we see the false advertising for natural claims, and certainly that's been preoccupying the courts for several years now, but we're also seeing a rise in these oil-free claims. So the basis for the claims is simply the products are not as advertised, with consumers underscoring the synthetic ingredients in purportedly natural products, and doing the same for oil-derived products, such as dimethicone or polyisobutene, in these purportedly oil-free products. So as you all may be familiar, the FDA has not defined natural. Courts, however, have interpreted the marketing language to mean the absence of synthetic ingredients. And then the National Advertising Division, which is part of the Better Business Bureau, so not necessarily a government agency, but an extension of the industry in the United States, they maintain that a product is natural when the active ingredients are not is natural where most of the ingredients, including the ingredients that are advertised, are natural, or a small percentage of the product ingredients are not natural. So the NAD has a little bit more of a flexible definition in which they sort of carved out, you're still okay, manufacturer, if only a small percentage or indiscrete amount is not natural. But as mentioned previously, courts, on the other hand, have sort of taken this more strict view that no, all the ingredients need to be deemed natural. So there's a little bit of ambiguity there, and it certainly makes it confusing for the industry, especially where the FDA has not made a regulatory decision or otherwise recommendation as to what natural means for cosmetic products. We, of course, know in the context of food that they have adopted what the courts say, which is natural means no synthetic ingredients. So you really have to be cognizant of that distinction and be mindful when you're using that marketing language. For oil-free, we really will have to wait and see how the courts interpret this marketing language and plaintiff challenges. because it's like natural, there's no uniform definition of oil and what that term encompasses. Next slide. So we wanted to touch briefly on, cosmetic reform at the federal level. In light of COVID, certainly the cosmetic reform in the United States has been put on the back burner. But these bills that we've noted here that have been pending since 2019 are very similar in form in the sense that they all have strategic initiatives. Number one being taking a look at our Food, Drug, and Cosmetic Act and bringing it into the present. There hasn't been any significant reform and amendments to that act as it relates to cosmetics over the past 70 to 80 years. So it's sort of the time is now, as these legislators that have introduced this legislation have encouraged that there needs to be some changes. And so what we see as a commonality between most of these proposed bills is getting the FDA in a position where they can ban certain ingredients, especially toxic ingredients that, like formaldehyde, and ensuring that these ingredients are barred expressly and not allowed in any cosmetic products in personal care products in the states. These bills also are intended to increase the FDA's authority. So right now, the way that our infrastructure works in the United States is a lot of the responsibility is borne by the manufacturer. So the goal of these bills is to put more control and authority in the FDA. For example, being able to recall products and direct manufacturers or distributors to stop selling products when there is an issue that has been disclosed by consumers or otherwise been revealed by the FDA's independent testing. And the other sort of piece here is to briefly talk about the Humane Cosmetics Act, which is slightly different as far as not focusing on ingredient specific and necessarily FDA's control, but this bipartisan legislation would end safety testing of cosmetic products on animals. And then also, as we noted here, is the Natural Cosmetic Act, which is going to help clarify what we talked about previously. What does natural mean, and what in what basis can cosmetic and personal care manufacturers use that language without the threat of there being litigation. And under the bill, it's again very interesting in the sense that it departs from what the courts are saying, and it departs from the NAD is saying. Under the bill, they're defining natural to mean a product consisting of at least 70% natural substances, and then a different definition for what's a naturally derived ingredient. So it'll be interesting to see if that bill ever takes form along with these others to help improve the cosmetic regulation and framework within the United States. Next slide. So we wanted to conclude here briefly by talking about the states. So as mentioned, with the federal regulation, we really see, a lag, so to speak, in the fact that there hasn't been any new legislation in over 70 to 80 years. And even with the activity in recent years, we're seeing it get stalled in Congress. So the states have taken it upon themselves to be proactive. One way we've seen this is with animal testing, with California, Nevada, Illinois, and Virginia, who have each passed laws banning animal testing in their state. And then the most proactive state is going to be California, which I'm sure you've seen in the news. They passed the Toxic Free Cosmetics Act, banning 24 ingredients from personal care products. And while the act does not become effective until 2025, you're going to see manufacturers start phasing out any of those ingredients to the extent they're not already excluded, to prepare for that installment of the bill. And the act is really intended to be consistent with the prohibition that's been enacted by the European Union. So California is following suit, and eventually, hopefully, other states in the country as a whole will follow. California also passed the Cosmetic Fragrance and Flavor Ingredient Right to Know Act of 2020. And this law requires cosmetic manufacturers to disclose to California's Division of Environmental and Occupational Disease Control a list of each fragrance ingredient or flavor ingredient that is included on a designated list. Because previously, most fragrances in other flavor formulations have been treated as proprietary. But with this act, California is sort of really pushing for more disclosure, more transparency to the consumer. And, that it'll be the division's responsibility to take that information data collected from manufacturers and devise a database for the public and for their use. And then we turn to customer privacy, which Tonya spoke about earlier as being a hot topic that the FTC, has been regulating. And then on California's front, they have had the California Consumer Privacy Act, or the CCPA, that's been in place since 2018. That gives California residents the right to know personal information that's being collected by a business. So as you may be familiar, if you have websites that are US facing, or you go on a website with a US consumer base, you'll always see certain disclosures that are specific to California, and that's a product of the CCPA. But California recently passed the California Privacy Rights Act, which is an extension of the CCPA that will take effect in 2023. And they're creating a new category of protected information called sensitive personal information, which includes biometric and genetic information. So California is trying to keep up with the times as businesses are expanding their use of technology and new methods that they're collecting this information. And while the federal regulators have not established a privacy protocol like our European counterparts, California is trying to fill the gap with these initiatives. So next slide. So that concludes our presentation. We want to thank Cosmetics Business Live for inviting us to participate in this program, and we hope that you've been able to take away some valuable lessons about the United States in terms of what the FDA and FTC are focusing on, what the plaintiffs' attorneys are looking at in terms of class actions, and likewise what both our federal and state legislators are focusing on to improve the cosmetic regulatory framework within the United States. Our information is provided there if you have any follow-up questions, and we certainly welcome the opportunity to answer those questions and to talk to you about any of your legal needs. Next slide. As a final point, we just wanted to highlight that while Tonya and I are based in DC, we have offices all over the country and work with manufacturers, retailers, and distributors all over the world, and therefore would welcome the opportunity to partner with you. So thank you so much.